I'm going to ask. So we're going to record this webinar, and I'm going to go over the details for that in 1 second. But first, I just want to welcome you all to this legislative update CLE put on by the state OPD, King County Department of Public Defense, and Team Child. And we wanted to bring you all here and put this on because I think there are a lot of exciting legislative updates coming out of this past legislative session. And so hopefully we can spend a little bit of time enjoying hearing about them because they are super excited and represent a ton of progress for our young clients in Washington. So you'll hear today from Katie Hurley. She works with King County Department of Public Defense. Many of you are probably aware of her work as a expert in juvenile justice in Washington, and she's really brought so much energy to making juvenile court a more fair place for youth, both in King County and across the state. And she's going to largely present for you on the registration advancements that passed through this session. She came into this legislative session with tireless energy to get this done, and optimism and strategy. And so I think it'll be wonderful to hear from her about all of these advancements that will benefit your clients. And you'll also hear from Karen Fuller, who is the Director of Public Policy at Team Child. As many of you know, Team Child is also a force to be reckoned with for our young clients, helping them in so many ways. And specifically, they were instrumental in getting these laws passed as well this session, largely thanks to Karen's hard work. And then you'll also hear from Yeannakis, who is special counsel here at the State Office of Public Defense. And I'm sure familiar to many of you as another pillar of, working to change things for the better for kids in Washington. So we're really excited to talk to you about all of the things that have gone on, and hope that you'll come with questions and with sort of ideas. We are going to record the webinar in its substance, and then we're going to ask that you hold questions to the end. If you want to put the question in the chat while you have it, we can collect those, but we're going to answer questions at the end of the presentation. And we're going to do that when the recording is off. That way, if you have any questions that are case specific or anything that you wouldn't want posted online, you can feel comfortable asking that question, and we can give you kind of a strategic answer to that, hopefully. So you'll hear that the recording's off, and then we'll start taking questions. And the recording will be available on the OPD website when this is over, and hopefully you'll get a link to that eventually. So without further ado, I'm going to turn it over to Katie. Thank you all for being here.
Thank you so much, Liz. And I realized I should have asked how to advance the slides. You'll do that? Okay. All right. Hi, everyone. Yeah, so I work with the King County Department of Public Defense and have worked for many years with other people to try to, well, we had set out originally to abolish sex offender registration. And Liz, you can move to the next slide. Because of the really extensive research demonstrating that youth sex offender registration is associated with some of the worst outcomes we can imagine for young people, including increased risk of suicide, increased risk of sexual victimization, many issues with housing, homelessness. Really, the literature is well documented about all the harms of registration. It's equally well documented that registration does not advance public safety in any way. It doesn't stop first-time offending. It doesn't stop subsequent offending. And so we really set out since the beginning, really of 2020 to abolish youth sex offender registration. And of course, we weren't able to completely abolish youth sex offender registration, contrary to the specific goal that we had. But we did make significant advancements in limiting the reach of sex offender registration. And so that's what House Bill 1394 does. And the bill contains some important legislative findings about the research from Johns Hopkins that's primarily been done by Dr. Elizabeth Letourneau and other people, including Dr. Caldwell, really looking at very low rates of recidivism for young people who engage in problem sexual behavior, and all of the research demonstrating the failure of these laws to improve public safety, and similarly the great impact that these laws had on young people and their futures. And so the legislature made those findings, and they also declared that the response should be developmentally appropriate, driven by research. And so I think to the extent that you end up having any hearings, we'll talk about this later, where the prosecutor is asking for discretionary registration, that these are findings that you can point to in explaining why registration is harmful, and that the legislature has recognized that. We could turn to the next slide. So House Bill 1394, the title is to create a developmentally appropriate response to youth who commit sexual offenses. And essentially what it does is it eliminates the requirement for registration for, I think it's fair to say most youth under 18, but it's really focused for those kids who are under 16. They only have to register, and we'll go through this in more detail on a slide, but they only have to register in very limited circumstances for first-time offenses. Kids who commit second-time offenses will have to register regardless of age, but we know that that number is a really small number of young people within the juvenile legal system. And so we'll see the vast majority of kids who are under the age of 16 will not have a registration obligation. And then for those young people who are 17 or 18 at the time of the offense, it is, you kind of look at if the young person is on a SOTA and at the class of the offense. And so we'll go into that more later. But as I kind of think about it, I'm thinking about the law in broad strokes. There's really those under 16 category, and then the 17 and 18-year-olds, you have to do a little bit more analysis about kind of the circumstances of their disposition and the nature. And this law applies to people who were under the age of 18 on the offense date and who were not convicted and sentenced of an offense in adult court pursuant to automatic or discretionary decline. So if it was an allegation was made after the young person had turned 18 based on alleged behavior that occurred under the age of 18, they would fall under the juvenile, the youth registration scheme. Even if they were declined to adult court, but they were found guilty of a lesser offense and the case was returned to juvenile court, then they would be under the youth registration scheme. Or for those young people who are declined to adult court and sentenced to adult court, they would be under the adult registration scheme. And then for those 16 and 17-year-olds, that piece about if they're on the SOTA is going to be very important to the analysis. So if they're on a SOTA, they won't have to register unless it's revoked. And then another really important thing that we did with this bill was that even if you do have to register, the timeline is much shorter. And so it's instead of, obviously for Class A's right now, it's a lifetime registration requirement unless you come back to court and ask to relieve. Now it will be 2 or 3 years duration, and that is supposed to automatically expire. And that timeline runs from the last date of release from confinement or disposition. And then we also have an extinguishing component for the legislation. So for those individuals who would not have to register under the new scheme, their registration will automatically end on November 1st of this year, 2023. And the sheriff's office is supposed to, officially, each registering agency is supposed to officially deregister people online and send a letter by December 1st, 2023. So kind of the main components are your age at the time of the offense. So if you do have to register, the registration period is much shorter. Automatically expires instead of these motions we have been having to make about asking the judge to relieve registration and considering a number of factors which are in any way linked to someone's likelihood for reoffense. And the whole thing was frustrating exercise and something that was a major hurdle for people being able to get that duty relieved. And then we didn't have that on the last slide, but another piece is that even if somebody is charged, we'll have it later on, for failing to register, then it will be as a gross misdemeanor rather than a felony. And then, of course, the extinguishing piece, which we, over 2,000 kids are on the registry for offenses that occurred when they were under the age of 18. And we think a substantial percentage of those young people will get their registration requirement extinguished later this year. Next slide. Thank you. And so it really, as I mentioned, it really focuses on young people who either have adjudications in juvenile court, who are charged as an adult because jurisdiction lapsed or the case was filed after they turned 18. And it does not apply again to young people who are declined and sentenced in court. That's a little provision that we tried to make sure was in there, the and sentence piece, so that if somebody is declined, but they have a lesser offense, that it comes back to juvenile court and they're under that youth registration scheme. We can turn to the next slide. And so, right, so as we were kind of talking about this breakdown of age groups, so if you're 16 and 17, you'll have to register on an A or B offense. If you don't get a SOTA or if your SOTA is revoked. Age 14 or 15, you'll have to register if it's a grade 1, which are very rare offenses in juvenile court for young people that age. We had asked for some data for the last several years, and there were only a few of these convictions for either rape in the first degree or rape in the second degree for young people who were aged 14 or 15 at the time of the offense. And then for the offense of rape in the second degree, somebody would have to register unless they did a SOTA or that SOTA was revoked. But those are the limited situations in which somebody under the age of 16 would register. The other one that we talked about for a sex offense, the other one that we talked about was if there's a prior sex offense adjudication, which of course we mentioned earlier is exceeding very, very rare in juvenile court. No changes were made to the registration requirements for kidnapping or unlawful imprisonment, although they are included in that duration change for the length of registration and the method of expiration. And then we'll talk about, I think on the next slide, the state motion for registration. And the timeline is 3 years from the date of release from confinement, the last date of release from confinement or disposition for 15, 16, and 17-year-olds on a Class A, and for other young people, it's 2 years. So basically everyone is 2 except for Class A is for those 15, 16, 17-year-olds at the time who are that age at the time of the events. And then no motion has to be made. It's supposed to automatically extinguish. Of course, this is a new process, and so we'll want to be watching it carefully to make sure that these registration requirements are being extinguished when they're supposed to. But that'll be something to kind of, if you have clients to try to, check into to make sure that, and we're going to be trying to check into it as well on a statewide level, but this is what the law says that the registering agency is supposed to be doing. We can turn to the next slide. This talks about the state's motion for registration. It really looks at it's the one kind of discretionary piece of the statute. And in order for a prosecutor to be able to have a young person who wouldn't otherwise be eligible for registration to be forced to register, it can't be on a SOTA. It's not applicable for those younger, the 12 and 13-year-olds who we see a lot of cases for in juvenile court, but it is unfortunately for the 14 and 15-year-olds as well as the 16 and 17-year-olds. They have to show 2 or more distinct victims in separate counts or causes. They have to show that they present a serious threat to public safety. And as you know, most of our sexual behavior and risk assessments don't show a serious threat to public safety in the evaluations. And they would also have to show that registration is required to lessen the serious threat to public safety. which I think would be exceedingly difficult to demonstrate because the research all shows that it's really unanimous that registration does not reduce the risk of recidivism. It doesn't make people safe. And so that's one of the reasons why we pointed to the findings at the beginning of the legislative findings at the beginning of this presentation. Because if we have to, and I'm not sure really whether prosecutors will try to bring these motions, but if they do, we'll want to point out why registration doesn't do anything to protect community safety. So I think it's an open question to what degree, if ever, prosecutors make these motions for registration, because I think it's fairly cabined who it applies to, and it's a fairly high evidentiary standard and findings that they would have to make. But we'll definitely be interested in hearing if there are attempts to do that in different counties in Washington. We can turn to the next slide. This is about sodas. So as we talked about, there's no registration during the soda. So of course, we don't need to waive registration at the end of the soda, as has currently been done. But if it's revoked, you have to register if it would have been, you know, if you were eligible for the original offense. So if it's like a Class C felony that someone's doing a soda for, like rape in the 3rd degree, when they do a soda, they still wouldn't have to register even if it's revoked, because they didn't have to register on the original offense. But if it's a 16-year-old doing a soda for a child molestation in the 1st degree, then they would have to register if the soda is revoked. And then, as we talked about, this will extinguish the registration requirement for individuals who are currently required to register as a result of behaviors that occurred under the age of 18 that weren't declined and sentenced in adult court. And so as we've talked about, it will terminate if they wouldn't be required to register under the new scheme. So, for example, if someone is on the registry for an offense, a child molestation in the 1st degree that occurred when they were 12, that was their first offense, then the registration requirement will be terminated automatically. If someone was registering as a result of a child molestation in the 1st degree from when they were 16, then they will have to register, and then it would terminate after 3 years. Now I'm having to do math. The 2 or 3 year period would terminate after 3 years. So I think it's for that reason, because of the narrowed range of offenses that are eligible for registration and that timeline, that we're going to see a lot of young people or a lot of individuals removed from the registry where the offense occurred when they were the age of 18 and they weren't declined and sentenced in adult court too. So that'll occur on November 1st, and then the sheriff has to remove everybody by December 1st, and they have to notify them of the removal. Of course, you know, I'm not sure like how updated all the addresses will be. Some people are will obviously certainly be experiencing homelessness and won't get notice of it, and so it'll be important, I think, for to the extent that you come into contact with people who had previous sex offenses from when they were under the age of 18, to be letting them, kind of giving them information if you can about the status of the registration requirement. If we go to the next slide. So one thing the statute did do, or the legislation did do, is kind of a package with the changes to the youth registration piece, is that if a person is sentenced to juvenile prison, they will have to do 24 months of parole for all adjudications related to sex offenses. Previously, it was for certain enumerated offenses, which were the vast majority of offenses that were sent to juvenile prison. I believe it's rape in the 1st degree, rape in the 2nd degree, child molestation in the 1st degree, rape of a child in the 1st degree, and rape of a child in the 2nd degree, and indecent liberties with forcible compulsion. So now if you have other offenses, they'll get that 24 months of parole. And that can be up to 36 months. I'm not sure what degree that actually happens, but they extend it up to 36, but they'll at least get that 24 months of parole and have to do, I believe they have to do treatment while on parole. And we could go to the next slide. So the record sealing impact, they're going, so I think Karen Blue is going to talk about this piece.
Yeah, I'm happy to talk a little bit about the kind of big picture work on record sealing. So the bill doesn't address, any changes to record sealing, but obviously anyone who no longer has to register has already accomplished the first step towards sealing their record for their offense. So if you look at record sealing for anyone with a sex offense, the first thing you have to do is be relieved of the duty to register. The rest of the conditions still apply. So you still have to wait the requisite amount of time, depending on the, depending on the conviction, right? So some people wait 2 years, some people wait 5 years. So that still is in place for everybody. But for people who have been on the registry for a long time without relief, that first step is going to happen for them automatically this year. They can start looking then at whether they qualify under those other time frames and other conditions. Team Child has done a lot of record sealing for young people, and we've tried to develop some materials. We are working really hard on updating all the record sealing materials so that they'll be available for people at hopefully as easy as possible pro se across the state. And our goal is to have all the materials updated by the end of the summer. Thank you, Haley. Our intern is helping us with that. But we also recognize that there'll be a lot of older people that are beyond Teen Child's age range, which is 12 to 24, who will probably be eligible to have their record sealed. We really hope those pro se materials will be helpful for them across the state. I think we'd hope that people will spread the word across the state. I mean, there's a little bit of a question about, I think, how much information people will have when they get notified by the sheriff that they don't have to register anymore, about the fact that now they can look at record sealing. So we may want to talk more over the summer about how to get the word out for folks, and brainstorm maybe strategies for people who are going to need the help, that are going to be too old for Teen Child. There might be defender teams across the state who can help with that, and there might be people in the civil legal services community who can help. But please know we're working on the materials so that we can try to make them as available to as many people as possible.
Thanks. If we could go back to the slide for 1 second, I actually didn't notice this. On the rape 1, rape 2, and indecent liberties with force. So it's my opinion that they're not eligible for mandatory sealing. So a judge doesn't have to seal if the person is crime-free for 5 years. But I do think people can make motions for them under 1350-260 subsection 3, which was recently analyzed in the Garza case, I believe. And so I think that I think it's not eligible for mandatory sealing, but there can still be some pathways to try to ask for discretionary sealing. So if we go to the next slide. And we talked about, I mentioned this a little bit, so now it's a gross misdemeanor if the requirement to register resulted from an offense occurring under the age 18 for which you weren't declined and sentenced in adult court. This piece is unlike the rest of the other elements related to extinguishing. This won't have an impact on people who previously obtained convictions for failure to register, felony convictions related to failure to register for a offense that occurred under the age of 18. And so now we could see those cases in municipal or district courts. There's been a lot of talk in Seattle about adopting the need to adopt municipal court or Seattle municipal code changes commensurate with the state RCW changes related to drug possession. I haven't seen a similar effort yet regarding failure to register. And so I think it's just important to, if you do see these cases in adult court, especially municipal courts, to see if there's been a kind of city level ordinance change adopting the ability to prosecute failure to register charges and then to investigate that. That's just something to be on the lookout for. So it's possible, of course, that the prosecutor's office could still charge them in Superior Court because they, have broad jurisdiction. But I think we'll have to see what different prosecutors' offices decide to do in terms of where they decide to charge these types of offenses. Another thing that the bill does is it expands some access for treatment. And so PCYF will establish a grant program. One piece of that was to allow defenders to apply for funding for evaluations and treatment if it wasn't being, if they weren't able to get funding from their counties through either expert evaluations, or if they wanted to do, sometimes in King County will do pre-adjudication treatment. So we'll say, if people are kind of worried about the ability of a young person to comply with treatment, sometimes they'll start treatment while the case is pending, and that's not always paid for by probation. And so trying to really be expansive as to how we think about, when there might be a need for evaluation and treatment, and if counties aren't paying for that, to provide other mechanisms for funding. This will be less interesting to you all, but it also expands who can provide treatment, including kind of indicating who can, like certified licensed mental health counselors, social workers can provide this treatment under the supervision of a sex offense treatment provider. The other thing that the grant program is supposed to fund is additional treatment modalities. So if counties want to try to look at evidence-based treatment modalities like multisystemic therapy, problem sexual behavior, or cognitive behavioral therapy related to problem sexual behavior, they can, the training costs for those programs are substantial. And so there's grant funding for counties to apply to if they want to try to kind of train up people locally who would be able to provide those additional treatment modalities beyond just the kind of normal SOTP group-based therapy that we have. So to provide some additional based options for young people. And so it can be more specific to kind of how they're presenting and what makes sense for that person and their family. George, did you unmute?
I did. So before I start talking about reducing legal financial obligations, I just want to point out how much effort Katie Hurley has put into getting this registration relief. Katie and I think started working on this at least 6 years ago. We thought we were going to get a bill passed 4 years ago, 2 years ago, 1 year ago. And throughout that time, Katie attended every sex offender policy board meeting, created groups. This is just an exceptional amount of work done here, and I really appreciate all the work that Katie has done. So the legislature also passed House Bill 1169, reducing legal financial obligations for juveniles and for adults. It was an effort by Representative Simmons to try to reduce the consequences of conviction. So the bill eliminates LFOs in juvenile court, except for restitution. Now, there was also a big effort to work on another way of providing victims with compensation for their loss. And I think that will continue to stand for Washington as leading that effort. So no non-restitution juvenile LFOs may be assessed in juvenile court. That includes fines, victim penalty assessment, the DNA sampling fee, diversion fees, copy fees, examinations for court-ordered evaluations, court-ordered treatment, probation bail fees, and no interest can be accrue on LFOs, non-restitution LFOs. Now, this also prohibits cities and counties cannot create their own juvenile fines and fees. There's some creative counties have tried to impose, the probation fee, I think, is one of the bigger ones. Payment, there's no requirement that parents pay for alternative evaluations for soda or mental health dispositions. And you can no longer charge for diversion fees. I think there's very few counties that do that, but they can't do it anymore. Now, payment of non-restitution LFOs can no longer be a condition of a juvenile sex offender disposition alternative. So the soda that we just talked about, that is a way of avoiding registration, used to have as a condition you had to pay all your LFOs. It's also no longer grounds for a probation violation. It still could be, if you didn't pay your restitution, it could be a probation violation, but not for an LFO. In order for non-restitution juvenile LFOs is no longer enforceable. So what does that mean, no longer enforceable? It means they can't bring you back into court and try to put you in detention or modify your community service. And outstanding debt for juvenile LFOs may not be collected by the juvenile court. So the court clerk can't dun you for, or your client for, past LFOs. They can't send it out for collections. In 2022, legislation eliminated juvenile detention fees at the state and local level and automatically waived the associated debt. Juvenile Rehabilitation Administration automatically waived the debt. However, court clerks around the state have not been consistent in trying not to collect that debt. So it's something we're going to have to watch when they also try to collect for these LFOs. There's no requirement that outstanding debt for juvenile LFOs be waived automatically. And we heard that sex offender registration after the 2 or 3 year period is automatically removed without even a court order. But there's no requirement that outstanding debt for juvenile LFOs be waived automatically, or even if a person files a motion. However, the fact that the debt is uncollectible and the debt for DNA and VPA fees must be waived if a person moves for waiver, may make the court more likely to waive all outstanding LFOs for juveniles. So clients should be able to get all their LFO fees waived with a motion, but it's going to take a court order to do that, as opposed to what Katie had talked about with registration, where after 2 or 3 years, it's automatically removed and doesn't require a court order. This is going to take a court order, and it's going to take the cooperation of clerks. That's something we're really going to have to watch. Okay, Karen? Oh no, Katie.
Hey, so we also wanted to talk a little bit about House Bill 1324, which relates to adjudications from juvenile court and how they score in adult court. Of course, previously juvenile adjudications would be used to could be used to increase someone's offender score in adult court, which would result in them mandatorily receiving more prison time, depending on the number of points, right? Of course, most misdemeanor adjudications didn't count, but some did, like vehicle problem, some tripled. There are all these impacts that juvenile adjudications had. And so now juvenile adjudications will no longer count in someone's offender score in adult court unless it's for murder 1 or murder 2. Or a Class A sex offense. And the other exception is juvenile sex offenses will continue to score on adult sex offense sentencings as they currently do. Of course, many of you may have heard there was a large effort, very significant effort to try to have the legislation be retroactive, which would have provided resentencings to many individuals in prison whose sentences were automatically increased due to juvenile adjudications. That did not pass this legislative session. But for sentencings, and obviously additional work will be done to try to have that pass in subsequent years for sentencings coming up. So we think there is an argument about, if someone is pursuing an exceptional down, an additional piece of that, maybe that person, if they had committed the crime a little bit later on after this, the effective date of the statute, then their offender score, their sentencing range would have been much less due to a reduced offender score from fewer juvenile adjudications being scored. And so I think there'll be some potentially sentencing work around the impact of this legislation, but if its effective date, should have this written down, I think is July 23rd. And so after that date, for offenses that occur after the effective date, adult court offenses, then that's when we'll really see this the impact of this House bill take effect. And when we were looking at this bill, it seems like about 20% of the sentencings in adult court are, there's an indication that they had offender scores that were increased or impacted by juvenile adjudications. And so we think the impact will be quite substantial. And I will turn it to Karen.
I wanted to add a little bit something about a bill that's not specifically defense related, but I think overlaps a lot with the experiences young people are having, and especially young people who might be facing any sort of status offense consequence. But House Bill 1406 made a small but I think significant change to how young people under 18 can access shelters, so licensed shelters, and hopefully safer shelter than being on the streets. So historically, a young person couldn't really be away from their parents' care without the parents' permission or some sort of intervention by the state for more than 72 hours. It's sort of the runaway kind of timeline kind of maxed out. And so House Bill 1406 really expands that time frame for a certain group of young people to 90 days. The two kind of categories of young people that can stay in shelter for up to 90 days without consent from their parents are young people where the parents can't be found or contacted, and if the parents refuse to allow them home. So if you have a parent who's saying, you got to get home, it's time for you to be home, they're not going to be able to stay in shelter without some sort of court action or intervention beyond that sort of 72-hour window. But for young people who are in those other two categories, there's a extended period of time for them to be in licensed shelters. The shelters are working on expanding their really their service kind of package and how they're licensed from all the different kinds of shelters there are so that they can accommodate people for up to 90 days. There's still a requirement in the law that the shelter notify DCYF, and some slight tweaking to the language that says that DCYF will offer FRS services, which is family reconciliation services, within 3 days of getting that contact. And the other thing the bill creates is something that they're calling a community support team, which is a pretty broad and flexible, flexibly defined support team that allows the young person to call in a group of people to support them in figuring out a long-term housing solution. There is a little bit of funding related to it that we hopefully will be able to use in this next year to establish some good examples of community support teams, and then probably will need to have expanded funding to keep to make this vision kind of a reality down the road. But I know that there's some overlapping issues with young people in the offender system and young people who are considered on the run or away from their parents without permission, or don't have parents to give permission. So I hope this will close at least a piece of that gap. And then I just wanted to say something else about safe shelter and in light of the registration bill. The very, very small group of young people who will be in a county detention facility facing a sex charge, who might be at risk of going to JR. Maybe they're at risk because of the nature of the crime. Maybe they're at risk because they haven't been deemed sort of suitable for a soda for a variety of reasons. Our experience at Teen Child is that a lot of times you're not suitable for soda if you don't have a family to support you at home and in the community. So the idea of a soda is that you have some place to live in the community and you can go to treatment, regularly. We at Team Child, even in our 4 offices, which that we serve, which are Spokane, Yakima, Pierce, and King, even though it's not statewide, we have seen plenty of young people denied the opportunity to do the soda because they don't have a safe environment to live in. Sometimes they're youth in the state care and DCYF foster care, but if they've burned out of a foster home and they're facing JR, they lose out on that chance to do the soda. And because of the way the bill played itself out, I think for us at Team Child, we're particularly interested in trying to help young people who fall in that gap. We want them to have that chance at soda. We want them to have that chance of avoiding registration altogether. And we actually have some funding that came out of this session to really target the young people who are in detention facilities who don't have a safe place to exit detention to, family not available, family not willing to have them. So the funding is for us to expand a little bit of our work to really target that. Even though we serve those 4 counties, Spokane, Yakima, Pierce, and King, this funding will allow us to look beyond those 4 counties. So trying to support people in this particular position in other parts of the state as well. We're not gonna be able to take them all. So there is a limit just to the amount of capacity we're able to grow. But I think this is a group that we feel a particular sense of urgency for, that we really, we didn't want necessarily all the limits that the bill ended up with, right? It was a compromise on some level. And for us, the compromise that there's a few young people across the state who don't have that safe or, available home environment to live in where they can really do the soda, it seems really unfair. We really want to prioritize whether we can solve those problems and allow those young people the chance to get soda. Sometimes young people end up at JR for other reasons, and it doesn't have to do with the family stability situation. But I just want to put that out there to you who are going to work with young people on the defense side. When you see those, that we really encourage you to contact Team Child in the next year to see if we can provide the advocacy that would help to create a housing or stable community environment for them so that they could really be eligible for the soda. So just putting that plug in there for the folks that are going to kind of face that risk, and specifically when housing is an issue.